Good afternoon, everyone. Thanks for coming along to this webinar about the updated guidance on limited title surveys. By way of introductions, I'm Lloyd McGarvey and I'm an Assistant Surveyor General based in the LINZ Christchurch office, also a licensed cadastral surveyor. My background, prior to joining LINZ in 2011, I worked in private practice for about 30 years. And with me today is Carl Wilton, and he'll be the main presenter. Carl's also an Assistant Surveyor General and Licensed Cadastral Surveyor, and he's based in the LINZ Wellington office. He joined LINZ in 2017 after about 20 years in private practice. Both of us regularly deal with queries about limited title surveys from both customers and our own staff, the LINZ staff. So this presentation covers the revised or updated cadastral survey guidance on limited title surveys, which went live on our website on the 6th of November, replacing the earlier guidance. For those who are familiar with the guidance, this presentation may serve to reinforce what you already know, but with some changes that will hopefully make the process easier. For those who don't feel that they're up with limited title surveys, then we hope this presentation will demystify some of the requirements and clarify the survey process. The revised guidance is the result of a joint initiative between Property Rights, Survey and Titles, and the offices of the Surveyor General and Registrar General of Land to identify and reduce difficulties associated with surveys and dealings involving limited titles. Stakeholders were engaged at the start of the process to identify pain points, and the revised guidance is intended to address some of these issues. So you may find your approach in thinking about limited title surveys changes after this presentation, and that's good. The main intention of the guidance is to clarify the survey process and clear up some common misconceptions. Just in terms of questions that you have, you're welcome to post questions as we go through the webinar, but please use the Q&A option, not the chat option. Patrick Cooper, LINZ Cadastral Surveyor in Hamilton, will be monitoring the questions as we go, and will post any answers that he can in the Q&A. We expect to have time at the end of the presentation to answer other questions, but those we don't get to today will be answered in the follow-up material we send out with the webinar recording. So that's the housekeeping. Now I'll hand over to Carl. Thanks, Carl.
Thanks, Lloyd. Okay, so what this presentation will cover today is the survey process to enable limitations to be removed from a title. And by limitation, we mean limitation as to parcels, not limitation as to title. Limitations as to title automatically expire after 12 years, so there shouldn't be any titles remaining that are still limited as to title. So when we're talking about limitations in this presentation, it's a limitation as to parcels. In today's presentation, I'll start off with a bit of background to limited titles and where they've come from. Then I'll go into the 3 steps of the survey process and the CSD requirements to enable limitations to be removed from title. And then I'll recap the key messages to take away from this presentation. So let's start off with a bit of background. Most limited titles are the result of the compulsory registration process, which was introduced by the Land Transfer Compulsory Registration of Titles Act 1924. The Act intended to bring all land that had been alienated from the Crown out of the deed system and into the land transfer system. The Act required land registrars to gather instruments of titles and plans, and from those documents, issue a land transfer title. The usual process for bringing land under the land transfer system included a survey of the land. However, in order to save the considerable time and cost of surveying the 70,000 parcels still in the deed system, the compulsory registration process did not require a survey to be carried out. And that created a couple of problems. Deeds documents usually included a delineation or plan of the land, but the plans and the delineations were a mixed bag in terms of accuracy and reliability. And because land was not surveyed as part of the compulsory registration process, the reliability of those dimensions was often unable to be confirmed before the new land transfer title was issued. Any inherent inaccuracy in deeds, diagrams and plans was brought through to the dimensions of the land shown on the land transfer title. Another issue was that under the deed system, occupation and possession was an important part of ownership of and title to land. In the deed system, title to land could be extinguished after 12 years of adverse possession. So after 12 years had passed, an adverse occupier could gain entitlement. By doing away with the survey, the extent of occupation and loss or gain of entitlement by adverse possession could not be confirmed before the new land transfer title was issued. The 1924 Act dealt with these problems by allowing limitations to be placed on the land transfer title. If the registrar was satisfied that the documentary owner was in possession of the land and that the boundaries were sufficiently defined by the instruments of title and plans, then they would issue an ordinary or fully guaranteed title. But if the registrar was not satisfied, then a limited title was issued. So the limitation serves as a warning that the parcel of land described on the title may not be reliable due to potential inaccuracy of the dimensions and area, and due to the possibility that title to some of the land may have been extinguished by adverse possession. If that possession started before the first land transfer title was issued, then the limitation protects the entitlement of the adverse possessor and their successors. So the two key elements to remember for a limited title are: the boundaries may not have been sufficiently surveyed when the first title issued, and adverse possession may have extinguished part of the title. So that's a brief background. So now you've been asked to carry out a survey to remove limitations. So what's required? The Land Transfer Act 2017 is the main driver behind the requirements. Sections 201 and 202 of the Land Transfer Act 2017 set out the requirements for removal of limitations. The registrar must be satisfied by deposit of a survey plan that no part of the land is held in occupation adverse to the title of the registered owner. The registrar must also give notice to adjoining owners unless those owners have provided written consent to the removal of limitations. Section 224 requires the land to be adequately defined, which means the deposited plan must be suitable for its intended function and comply with the cadastral survey rules. Unsurprisingly, these requirements remedy the two key elements of the limitation, i.e., the land must be fully surveyed to current accuracy requirements, and adverse possession must be excluded from the surveyed parcel. And this theme follows through to the survey process for removing limitations. The boundaries need to be accurately surveyed, and any adverse possession needs to be dealt with. To carry out these tasks, the survey process can be broken down into 3 steps. The first step in the survey process is to define the extent of the land described in the title. We can't determine if there is adverse possession if we don't know where the underlying title boundaries are. So the first step is to define the extent of the land described in the title. The second step is to assess any occupation that encroaches inside the boundaries defined in step 1. If the encroaching occupation meets the criteria for adverse possession and has therefore extinguished title, then that land must be excluded from the new parcel. The third step is to determine whether there is any adverse possession by your client over adjoining limited titles. That land can be included in the new parcel. This third step, step 3, is not technically part of removing limitations, but it is a step that is usually carried out at the same time as removal of limitations. So that's the 3 steps of the survey process. Let's go into each step in a bit more detail. In step 1, the aim is to define the boundaries of the land described in the title. So let's have a think about what we're dealing with here. Title has been issued to the full extent of the land parcels described in the title, and those parcels are represented by the primary parcels that exist in Land Online. So the boundaries of those parcels need to be defined in the first instance, and that is step 1. The limitation on the title means that title to some of that land may have been extinguished by adverse possession. But we don't know what land is adversely occupied until the original parcel boundaries have been defined. This is why we define the underlying title boundaries first in step 1, and then we assess for adverse possession in step 2. So in step 1, we are simply defining the full extent of the land described in the title and replacing the associated primary parcel in Land Online. And that's the same definition task and process that we carry out when we survey a fully guaranteed title. We define the full extent of the land described in the title using all available evidence. So boundary definition in step 1 is effectively the same definition process we carry out when defining the land in a fully guaranteed title. But with limited titles, there is often less evidence available, and it might not be as reliable. However, that's not always the case. Sometimes there is good evidence, and sometimes boundary definition can be quite straightforward in a limited title survey. At other times, it will be the same as surveying an old fully guaranteed title where a connection into the old underlying survey work is not possible, and other evidence must be utilised to redefine the boundaries. So let's take a look at evidence. Evidence sources will usually include dimensions from title documents, underlying survey work, if there is any, surrounding survey work, if there is any, the pattern of occupation, and other evidence. So let's talk these through. Dimensions from title documents. Despite the possibility that these could be of dubious accuracy, the title diagram and dimensions should not be assumed to be incorrect or of no value. In the absence of an underlying survey, they are the starting point for determining the extent of land held in the title. Some title dimensions might be quite accurate because they were derived from a survey. Deeds plans typically don't show survey work, but that doesn't mean they weren't surveyed. The clip on this slide indicates the land in this particular deeds plan was surveyed, and later surveys found old pegs, which agreed very well with the dimensions on this plan and with another deeds plan to the south. And that deeds plan to the south happened to have no mention that it was surveyed, but pegs were obviously placed. So keep an open mind as to the accuracy of title dimensions. They might be quite accurate or they might not. Underlying survey work. For limited titles, there often isn't a record of underlying survey work, hence the limitation on the title. But as I just mentioned, don't assume that there isn't any underlying survey. Some limited titles are supported by SO plans or deeds plans that have been surveyed. So always search thoroughly for survey plans and survey information. Surrounding survey work. Surrounding surveys obviously contribute to the boundary definition. It's useful to understand how those plans determine their boundaries. They may have relied on occupation to define boundaries, or they may have held title dimensions fixed, or they may have distributed a shortage and excess by a proportional method. Surrounding plans may also point you towards other plans that are useful. And don't restrict your searching only to plans immediately adjoining the subject parcel. Some old plans show occupation information across multiple parcels, and that can be very useful for determining the pattern of occupation that existed in the past. So make sure that the survey plans in the wider area are searched. Plans that define road corners and frontages are worth looking at too, so that you can see how the road boundaries were established. These can sometimes reveal how a shortage or excess came into being across a block. The pattern of occupation. I'll talk more about occupation on the next slide. Other evidence such as historical photography and oral evidence can also play an important part. The LINZ website is a very useful resource for historic aerial photography, and I recommend searching old aerial photographs to get an understanding of how the occupation has evolved over time. So it's important that all relevant evidence is gathered and assessed. Different sources of evidence have different levels of reliability, and they can produce different answers. We deal with these differences by applying the hierarchy of evidence. The hierarchy gives certain forms of evidence prominence over others, but evidence lower in the hierarchy can prevail over higher evidence if it is less likely to be mistaken or an error. Two forms of evidence that nearly always go head to head in limited title surveys are title dimensions and occupation. Title dimensions often fall into the calculations category of the hierarchy, and where occupation does not provide good evidence of the boundary, then title dimensions will usually prevail. But where the accuracy of title dimensions is unknown or questionable, then sufficiently reliable occupation evidence can override title dimensions within reason. So let's turn our attention to occupation. Before we focus on the role of occupation in step one, let's just talk more generally about the role of occupation in limited title surveys. The role of occupation in limited title surveys is something that often trips up surveyors. To successfully navigate your way through a limited title survey, it's important to understand the differing roles that occupation plays in step one and in step two, and not to confuse them. Occupation is the extent of someone's use of the land. In step one, we're looking at that occupation to see if it provides evidence of the title boundary. In step two, we're looking at occupation that sits inside the parcel boundaries determined in step one to determine whether there is adverse possession. So as per the heading on the slide, in step one, we're only looking at occupation with a view to see if it provides evidence of the title boundary. Here, occupation is effectively playing the same role as it would in the definition of a fully guaranteed title boundary. In other words, if it is to prevail, then it needs to provide better evidence of the boundary than the title dimensions. And the hierarchy of evidence confirms that undisputed old or long-standing occupation can be the best evidence of a boundary. But there are some conditions established by case law that need to be taken into account before occupation can be used as the primary evidence of a boundary. Occupation should be long-standing and undisputed by adjoining owners. In step one, it doesn't have to predate the first title, but it should be long-standing. Relatively new occupation that replaced the earlier occupation in the same location can provide evidence of the original title boundary. So this is where looking through old aerial photographs can be quite useful. The occupation also needs to reasonably represent the boundary. If the occupation produces a striking difference in dimension or in the shape of the parcel, compared with the parcel shown in the title, then that occupation may not provide suitable evidence of the boundary. The impact on adjoining parcels and entitlements should also be considered. So have a look at what effect it has. If you accept the occupation as the boundary, look at what effect it has on adjoining parcels and surrounding ownership. Give and take fences and fences of convenience do not provide evidence of the title boundary. So you should always look into whether a fence is a give and take fence or a fence of convenience. This can sometimes be the case where a fence was erected between two parcels of land held by the same owner and was never intended to follow the boundary. Or more commonly, the fence might be placed in the most convenient position due to topography. So the fence was not put on the boundary, it was just put on an alternative alignment. So it's not the case of using occupation carte blanche as evidence of the title boundary. If occupation is to be considered the best evidence of the boundary, then it still needs to represent the general shape, size, and the area of the parcel described in the title. Occupation that produces striking differences may simply be a case of encroachment, or it could be adverse possession. So your evidence gathering and judgment is very important for determining whether occupation is the best evidence of the boundary. And as many of you will have experienced, boundaries defined on the basis of occupation will usually produce dimensions that do not exactly match the title dimensions. So let's have a little bit of a talk about differences. When defining the extent of land held in a limited title, differences with title dimensions are likely and okay to a degree. As mentioned on the previous slide, a boundary definition derived from occupation is likely to produce differences compared to title dimensions. And other evidence and factors may also contribute to boundaries being recalculated away from title dimensions. And that's okay, providing the difference is not striking. You've heard me using the term striking a few times now. This term comes from the Attorney General versus Nicholas case, which is an important legal case dealing with occupation as evidence of a boundary. So by striking, we mean that the difference should not be out of kilter with the general accuracy or inaccuracy in the area, and it shouldn't leave any other owners with a significant shortage. The resulting shape of the boundary or parcel may be slightly different, and that's okay so long as the parcel still provides a reasonable representation of the land described in the title. A look at surrounding surveys and how their boundaries were defined can give clues as to why differences are present. If surrounding surveys have also used occupation to define boundaries, then differences are likely. And this may support your current survey taking the same approach to definition. Shortages and excesses may arise, or may already exist due to existing survey definitions. Shortages and excesses should be distributed in the normal manner, i.e. in accordance with priority, if there is any, or in accordance with occupation as far as possible. In other words, leave shortage or excess where it lies on the ground as much as you can. Mathematical distribution should usually be a last resort. And the boundaries can only be as good as the evidence allows. And the differences between the final parcel dimensions and the underlying title dimensions are not restricted to the accuracy tolerances. If the evidence puts boundaries in a particular location, then those boundary locations determine what the dimensions of the parcel are. And a difference does not mean there is a residue parcel. So if you end up with boundary dimensions that are not the same as the title, that are in excess of the title, that does not mean there is a residue parcel. In recent times, there's been a tendency by some to think that an excess over a title dimension means there must be a residue parcel. A difference does not mean there is a residue parcel. And remember, sometimes we get shortages and excesses with fully guaranteed titles too. That doesn't mean there is a residue in those cases either. Now let's talk about common boundaries. So there's a new clarification in the revised guidance, and that new clarification is how existing boundaries from previous removal of limitation surveys can be dealt with. Where a neighbouring parcel has had its limitations removed on an earlier survey, the boundary defined on that neighbouring survey can usually be treated as the common boundary within the land now under survey, provided that the neighbouring survey did not indicate an intention to leave a residue. So to check whether it left a residue or not, or intended to leave a residue, the neighbouring survey and its survey report should be reviewed to confirm that its intention was to define the common boundary between the two limited titles and not leave a residue. If it can be reasonably concluded that this was the intention of the adjoining survey, then the boundary from that survey can be treated as the common boundary of the land now under survey. And that's the case even if the common boundary defined by the adjoining survey has angles in it when the boundary was originally straight, when the title boundary was straight, or if the neighbouring survey took a shortage and left an excess in the land now under survey. When you're looking at what the adjoining survey did, make sure you go back to the survey that actually removed the limitations. Subsequent surveys over the top of that survey will have adopted the boundary and probably won't have the information that you need to find. So just to reiterate, you're looking to check that the adjoining survey did not intend to leave a residue. And if it didn't, then you can accept that boundary it defined as the common boundary between your title and the title next door. And don't forget that the boundary marking requirements for removing limitations still apply to the common boundary. So you will need to reinstate any marks that are missing or locate any old marks on that boundary that are still in place. Okay, let's move on to an example. This is DP 331958, and I think this provides a good example to demonstrate some of the concepts we've just covered. DP 331958 was a 2005 survey under the 2002 rules. The underlying title was issued in 1932. And what the surveyor here faced was no underlying survey, no bearings on the title, as you might be able to make out in that title diagram. It only shows distances. The northern boundary was defined by a plan to the north, DP 320797. And that produced a boundary that was about 0.35 metres shorter than the title dimension. An alignment for the road and the rear boundaries was established by DP 320797. And there was a regular occupation on the south boundary, a fence, a couple of retaining walls, and then another section of fence. And the ages of that occupation ranged from over 15 years to over 50 years. So where are the underlying boundaries of our title? Let's try and hold the title dimensions and straight line boundaries to see if we can make it fit. So the red shape is the title dimensions aligned with the road frontage and the western portion of the northern boundary. And you can see that this produces gaps and overlaps with the existing boundaries and occupation as indicated by the figures. So we've got a gap of about 1 metre at the north and then another gap between the occupation of 0.6 at the south. We can do it differently. The blue shape is the title dimensions aligned with the road frontage and then aligned with the longer northern portion, the eastern portion of the northern boundary. And this produces a squarer parcel shape, and it also produces gaps and overlaps of a similar magnitude, but in different locations. Many other variations are possible, and because we have no underlying bearings for the boundaries, each solution is effectively a guess at what the original bearings may have been, and this affects the parcel shape. So we can see that trying to hold title dimensions and keeping the northern boundary as a straight line boundary simply won't fit with existing survey work. So how did this survey play out? DP 390797 showed no intent to leave a residue. The northern boundary was treated as the common boundary with a limited title, and the resulting boundary dimension was about 0.39 shorter than title. The road frontage and rear boundary alignments established by DP 320797 were held, and DP 320797 had determined there was a 0.16 metre shortage along the road frontage down to the road corner to the south, and an overall 0.88 metre shortage excess along the rear boundary. DP 331968 distributed the shortage and excess by pro rata, taking 0.07 of the shortage in the road frontage and 0.37 of the excess at the rear. I think DP 331968 could potentially have distributed the shortages and excesses in terms of occupation instead of using pro rata, but it looks like it wouldn't have made a significant difference to the final outcome. In the adjoining parcel to the south, a 0.09 metre shortage was left in the road frontage and a 0.51 excess left at the rear. On the southern boundary of Lot 1, the general line of occupation was considered the best evidence of the boundary, so the boundary was defined as a best fit with that occupation, resulting in 2 new angles in the boundary and the overall length of the boundary being about 0.23 metres shorter than title. No residue parcels were created and no adverse possession was claimed. So is this definition okay? When we take a step back and look at the overall shape and the width and length of the parcel, the overall parcel shape is similar to the parcel depicted on the title, and the dimension differences seem reasonable given the magnitude of the existing shortages and excesses in the block. The definition methodology that is similar to definitions that had already been carried out in the block. So a similar approach was taken by DP 320797 to the north. And the parcels to the south don't appear to be disadvantaged by this definition. So if you were undertaking the survey today, then with sufficient analysis and reporting, this definition can be justified and is an acceptable boundary definition for step 1. Okay, so we've defined the title boundaries in step 1. Let's now move on to step 2, excluding adverse possession. The aim of this step is to determine whether any part of the title has been extinguished by adverse possession. We do this by comparing the position of the occupation to the boundaries defined in step 1. Any occupation which sits inside the boundaries needs to be assessed for its age. If that occupation predates the issue of the first limited title, or its newer occupation in the same position as earlier occupation that predated the first limited title, then the occupation meets the age criteria for adverse possession. The second part of adverse possession is the quality and nature of possession, or in other words, how the land has been occupied. This also needs to be considered. There must be an intent to possess by the occupier and the possession must be actual, open, manifest, continuous, and exclusive. And you need to give regard to the character and position of the land, because that can also affect whether the nature and quality of occupation meets the criteria. Fences of convenience and give and take fences do not support adverse possession. Evidence such as historic photography doesn't just have to be aerial. Useful photography, old photography can be found from other sources such as the National Library. The evidence, survey plans and other information should be utilised to try and determine the age and nature of the adverse occupation. The relationship between current or prior owners of land on each side of the boundary can impact adverse possession as well, and that should be investigated. So if the age and quality criteria appear to be met, then the occupied land should be excluded from the new parcel and defined in a residue parcel. A residue parcel is necessary because the limited title was issued for the entire primary parcel, but the new fully guaranteed title is only going to issue for part of it. So we need to fill the missing part with a residue parcel. If a residue parcel is created on your survey, then it must be justified in the survey report, i.e. you need to provide confirmation that the age criteria appears to have been met and the quality and nature of occupation appears to meet the adverse possession criteria. And you'll need to describe the evidence that supports these conclusions. And the evidence can be subjective and inconclusive. So more likely than not, or on the balance of probability, is a sufficient level of certainty to support the creation of a residue parcel at the survey stage of the process. A residue parcel is not allowed if the criteria are not met. So if the age and quality criteria for adverse possession are not met, then the land cannot be excluded and a residue parcel should not be created. Past practice has sometimes been to allow residue parcels to be created for any encroaching occupation, even when it didn't meet the age or quality criteria. But creation of residue parcels in those circumstances, where there's no qualifying adverse possession, is effectively subdividing the land without authority, and that practice is no longer allowed. So if there is encroaching occupation, but it doesn't appear to support adverse possession because it doesn't meet the age criteria or the nature and quality of the possession doesn't meet the criteria, then a residue parcel should not be created. And the reasons why that encroaching occupation doesn't meet the criteria for adverse possession should be reported on. That might be as simple as stating that the age criteria has not been met, but the reporting needs to confirm the evidence used to reach that conclusion. And the same on the balance of probabilities test is sufficient here. So in summary for step 2, if there is occupation encroaching inside your step 1 boundaries, then assess it and report on it, either justifying the creation of a residue parcel or confirming why the encroaching occupation doesn't meet the criteria for a residue parcel. If there is no encroaching occupation, then a statement to that effect will demonstrate that the step 2 assessment has been completed. Accurate analysis of the age and nature of possession can be quite difficult. The limited titles guidance provides more information on adverse possession, and further information can also be found in the CSDs with adverse possession guidance article. And of course, legal advice may be advisable if the situation is complex. Okay, so now the final step, step 3, including land from an adjoining limited title. This is where your client's occupation encroaches outside the step 1 title boundaries and onto neighbouring land that is or was held in a limited title. If it meets the requisite criteria, then the occupied land may be included into your new parcel. It's important to note step 3 is only for encroachment over a neighbouring limited title, not over a fully guaranteed title. And step 3 is not technically part of removing limitations, but it is a step that's often taken at the same time as the removal of limitations. And there are 2 scenarios here, including land from a cancelled limited title or including land from a live limited title. The cancelled limited title scenario primarily deals with inclusion of existing residue parcels into your new parcel. Example of existing residue parcels are shown in these diagrams or these clips on the slide. And the residue from the modern e-survey will appear as an existing parcel in Land Online. So that's a pretty easy one to see and detect. But the residue parcels on the older 2 surveys probably won't exist as parcels in Land Online because they're unlikely to have been captured in the past. However, by the time you get to step 3, you'll probably know they exist, and that's because in step 1 you will have investigated those adjoining surveys to see if their boundaries can be taken as the common boundary or whether they left behind a residue. And as you can see in these clips, there's pretty clear evidence of residues being left here. And the second scenario on the slide is including land from a live limited title. And this scenario is where your client is occupying part of their neighbour's land. It's not a residue parcel. It's actually part of the land that the neighbour owns through a live limited title. So it's basically encroachment into your neighbour's parcel. So we'll just go back to including land from a cancelled limited title. So this is the scenario that primarily deals with inclusion of land from an existing residue parcel into your new parcel. And these residue parcels tend to be parcels that have been left as the result of earlier removal of limitations. And their underlying titles are usually cancelled as part of that process. So these residue parcels will usually not have a live limited title. It will just be part of they'll be in a cancelled limited title that was cancelled when limitations were removed. So the scenario for including this land comes up when your client is substantially occupying a residue, an existing residue parcel, and wants to obtain title to that residue. Obtaining title would usually require an adverse possession application to be made as part of the title dealing. But the good news here is that we're trying to make the process easier for including these residues into the land under survey. So in this scenario, the RGL is open to reducing the application requirements that would normally apply if you were going to include that land in your new parcel. And the reduced application requirements are dealt with on a case-by-case basis. So prior to the lodgement of the CSD, a titles information request should be submitted via Land Online by the surveyor or solicitor asking whether an application will be required. Ideally, that request should include an explanation of how the residue came about, and it should include a draft survey plan showing the additional land being included, together with occupation information. You can proceed with this request even if the age of occupation does not appear to predate the first limited title. And another couple of things to note, even if the outcome of the request is that an application is not required, the deposit of the survey plan will still be subject to the adjoining owner notice or consent provisions under Section 202 of the Land Transfer Act. So there's benefit in obtaining adjoining owners' consents. And that might, and if you get them before you make the request, then that may help the RGL with their decision on application requirements. And don't forget that the survey rules require existing boundary points to be marked when limitations are being removed. So this will also apply to the residue parcel being claimed. The disappearing residue boundary doesn't need to be marked, but it should be shown as an estate boundary together with estate references and the area of the residue parcel. So you can see that demonstrated in the diagram on the slide. The second scenario is where your client is occupying part of their neighbour's land and the neighbour's land is held in a live limited title. If the encroaching occupation predates the first issue of the neighbouring limited title and it meets the quality criteria for adverse possession, then that adverse possession may have extinguished the neighbour's entitlement to that portion of land. And the adversely possessed land can therefore be claimed and included in your new parcel. In this scenario, a full adverse possession application is required. So there's no point putting in a request in this scenario. The full application will be required. The CSD therefore needs to meet the appropriate capture and depiction requirements to support an adverse possession claim. So the area being claimed needs to be identified, usually by showing the estate boundary and estate references, together with the area of land being claimed. And a residue parcel needs to be created for the balance of the neighbouring limited title. You should also report on the evidence that supports the claim. The limited title guidance and the guidance for CSDs with adverse possession provides more detail about the CSD requirements for this scenario. So that's the 3 steps covered. Now we'll have a look at the particular CSD requirements that usually apply for limited title surveys. Boundary marking is required at all existing boundary points of parcels that are having limitations removed. Adopted boundary points are only permitted on existing boundary points that are impracticable to mark. Occupation information is required at every boundary mark and along every existing boundary. Adjoining owners' consents are not mandatory, but they are useful. Adjoining owners who have not provided consent will be notified. There's a 40-day notice period, so it can delay your dealing getting processed. Early notification can be requested as soon as the CSD is approved using an adjoining owner notices request in Land Online. So this means you can get the 40-day period running before the dealing has been submitted. So that can help speed things up. And the survey report. So good reporting is key for limited titles. My suggestion to you is that you structure your report to cover off the 3 steps. So start with the underlying title boundaries, report on the evidence gathered and decisions made to determine the position of the underlying title boundaries. That's step 1. Then report on your analysis of the occupation in relation to those boundaries. Report on any occupation that encroaches inside the title boundaries from step 1 and confirm whether that occupation meets the criteria for adverse possession and hence there's a residue parcel being created in the CSD. Or confirm that it doesn't meet the criteria for adverse possession and therefore there is no residue parcel for that encroaching occupation. The evidence used to make those decisions should be reported on and then step 3. Oh no, finally for step 2, also if there isn't any occupation encroaching inside the boundaries, then say so in your report and that makes it clear that you've undertaken the assessment in terms of step 2. Similarly for step 3, if land beyond the title boundaries and determined in step 1 is occupied by your client and being included in the new parcel, then report on the status of the underlying land. For instance, is it a residue in a cancelled title, or is it a live limited title? When was the first limited title issued for that land? What is the history of the occupation? What evidence was gathered and used to make the decisions? Check in with our guidance articles for more information. We do have more information about what you should be including in the report. And that brings me to my last slide. And that's the key messages that I'm hoping you'll take away from today's presentation. So the first message, understand and use this 3-step process to carry out your survey. Remember that the purpose of the survey is to define the boundaries of the land parcel described in the title and to address any adverse possession. If you remember these 3 steps, then I think it makes it much easier to understand the survey process for a limited title, and I think you're more likely to get it right. Second message, understand the differing role of occupation in each step. In step 1, occupation may provide evidence of the title boundary. But in step 2, we're looking at occupation from an adverse possession perspective. And same in step 3. Again, understanding the different role in each step makes these surveys much easier to carry out. The third message, occupation can provide evidence of the title boundary in step 1. There may be conflicting evidence, so apply the hierarchy of evidence. In the absence of any underlying survey work, long-standing occupation can be the best evidence of the boundary and can prevail over the title dimensions, provided that it doesn't produce a parcel that is strikingly different in dimension and shape to the parcel described in the title. It shouldn't be assumed that title dimensions are inaccurate, but you also shouldn't assume that they must be held fixed. Fourth message, prior limitation survey boundaries can be held as the common boundary between titles, provided that the adjoining limited title survey did not intend to leave a residue. If there is no evidence of residue, then the boundary can be accepted as the common boundary between the titles, and there'll be no gaps or overlaps between the titles. The fifth message, residue parcels should only be created for adverse possession, and not because there is an excess over title dimensions, or because there's encroaching occupation by a neighbour that doesn't meet the criteria. And the last message, inclusion of residue parcels from cancelled limited titles can have reduced application requirements. We're trying to make the process easier for land and existing residues to be included into new titles. So if you encounter one, then seriously consider including it into your land that you're defining. So that's it for my part of the presentation. Hopefully you found this presentation useful and you're now looking forward to getting your teeth into your next limited title survey. I'll hand you back to Lloyd.
Thanks, Carl. We've, what is it? It's coming up 5 to 1. We'll start looking at some of the questions now. It looks like some people have had some issues with getting questions into Q&A, but we'll at least get to some of them. So we can carry on for an extra 10 to 15 minutes after 1 o'clock to answer questions. But if you can't stay after 1 o'clock, then still feel free to post any questions you have in the Q&A, and we'll try to answer them so they're on the recording or in the follow-up material we send out with the webinar recording. Okay, so Carl and I will do a bit of tag teaming here. And let me just see. Okay, I'll look at the first question, I think that was posted in Q&A. Phil said, not all limited titles come from the deed system. Resident site licenses were a license to occupy an area of Crown land. These transferred to Lands and Survey when the mining courts closed in 1965, and many have little definition. Can these be subject to adverse possession? Great question, Phil. You're talking about I think it's the Mining 10 Years Registration Act that covers this situation. That is not the only legislation as well that resulted in limited titles being issued. Our guidance and this webinar admittedly deals with limited titles that came into existence under the compulsory registration provisions of the Land Transfer Act 1924. Another interesting case is under, I think it was section 167 of the Land Transfer Act 1952. The registrars could issue limited titles if they considered there was a case of hardship. So there are a few instances you'll come across where a piece of land was held in a guaranteed ordinary title, but the registrar is allowed a subdivision to occur without a survey plan and has instead issued limited titles as a result of that process. So all those instances raise the question of whether these can be subject to adverse possession. With resident site licenses, we've been dealing with these on a case-by-case basis as a few come in every now and again. Generally, my understanding is that they have been dealt with as though they can be subject to adverse possession. We're currently in discussions with the Registrar General of Land to try and clarify this, because it is one of the pain points that was addressed that was raised in the review that we've been doing. But because they don't come up very often, we didn't give a priority to that aspect. But hopefully we'll soon be able to provide some clarity on that, Phil. Next question, I'll have a go at it. Where there is an SO plan defining a limited parcel, is it possible to carry out a redefinition survey? This would be a definition of the original parcel and could not result in the removal of limitations. In terms of the Cadastral Survey Rules 2021, you can't do a boundary reinstatement survey of a boundary held in of land that's held in a title limited as to parcels. So if I understand the question correctly, the answer would be no, you couldn't do that redefinition survey. Carl, I'll let you have a turn shortly. Elliot has asked if Rule 35(2)(d) is applicable to boundary points created by adjoining or adjacent surveys which intersect an existing boundary of the title under survey. That is, boundary marks placed by an adjoining survey which intersect a straight boundary of the subject limited title. Are we expected to ground mark all of the existing boundary points along the straight line of our limited title? Another good question, Elliot, and we're in a situation like that, our view is that the 35(2)(d) doesn't necessarily require you to mark all the boundary points along that line. It does require you to define the points at either end of a boundary of the boundary, but I would put a proviso there that those boundary points along that boundary may be key evidence for determining where the underlying title boundaries lie. So you you may need to look for them and determine whether the boundary is in fact still a straight boundary or not. Carl, do you want to have a go at the one about retaining walls, or should we have a think about that one and come back to it?
No, I can probably make a couple of comments there. Look, I'm not sure there's best practice as such. When you're talking about a structure that is defining the extent of occupation, it's going to vary from case to case. And when I think about some of those big wide old stone walls up in Auckland and other parts of the country that you get, that area that's actually occupied by that structure, it's pretty hard to say that one person is occupying it instead of the other. So it really becomes a judgment call in the case you're dealing with this. There's I wouldn't like to say there's any hard and fast rules. You might take the centre line. It's just depends on the situation really. So you're sort of trying to look at. It depends whether you're looking at it from a step 1 or step 2 perspective as well. So in step 1, you're looking to see whether it's evidence of the boundary. Retaining walls, they can be a bit of a mix of reasons. They're often there to support land. Is that an intent to keep someone else out? It just depends. So in terms of adverse possession or evidence of the title boundary, it's really a judgment call that you have to make based on what you find on site and the history of occupation there. And yeah, it's case by case really.
Thanks, Carl. I think Phil's made a comment. Many of the residue and adverse possession parcels are very small, and people simply do not want to go to the bother and expense of claiming them. The neighbour cannot claim them if they remove limitations, so we just identify the occupation in our data set to demonstrate the adverse occupation. Appreciate that, Phil. I think in terms of existing residue parcels, as Carl's explained in the presentation, I mentioned a couple of times, we're trying to make it easier for existing residue parcels to be claimed, and there's a likelihood that if an application for adverse possession is not required by the RGL, then there's really very little extra expense involved in including the residue parcel. So I'd encourage you to consider that option if you come across that. Yep, adverse possession of an adjoining live limited title. I appreciate that. Yeah, encourage you to try and claim it, but yeah, again, appreciate that if it's just a sliver of land, then it may not be worth the bother and expense. And I will just mention there that Carl mentioned that there's a land online request available to both one for each of title users and survey users called adjoining owner notices. That's just become available in Land Online in the last day or two, so that can be used. That's the appropriate request to use now by lawyers or surveyors to request early notification. Carl, do you want to have a go at, I think it's Brent's one about the roadside
boundaries where road is the vest. Yeah, look, my view is that it probably does apply. 35.2D would apply there. But if you don't feel that it's reasonable to mark those, so if it's already in the road and the occupation is already established, then yeah, there's probably a reasonable argument that it's not much point in doing that. So again, case by case basis there. The Rule 35.2D does require those points to be marked, but yeah, apply for dispensation if you think that that it warrants it.
Yep, Brent's added a comment to his question where he says obviously dispensation could be requested on the basis that it's not practicable, possibly because it's not not reasonable to do so, Brent. Why can't automatic dispensation be available? Well, that would actually require a rule change. That automatic dispensations, yeah, they don't happen. You've got to apply for them. Okay. Kurt, you've asked where LINZ is asked to notify a neighbour about a removal of limitation survey, but there is no known postal address or contact details for that owner. What can LINZ do? I don't think Carl or I can answer that question. It's something we'd have to ask our titles colleagues, but yeah, we'll do that and provide an answer. What's the next one? Hayley, you've posted one from Lionel Foster. To claim adverse possession with the title compared have to be the title that issued after evidence of occupation with the limitation as to title. I think we're talking about the difference between step 1 and step 2. Is that your take on that question, Carl?
I'm not sure, or is it step 3 to claim adverse possession?
With the title?
Yeah, with the title compared.
Not
entirely sure.
Yep, not entirely sure there, so we'll skip over that one. Where are we up to? Thanks, Carl. Russell's asked, link to adjoining owner consents, please. I think you're meaning a standard form for an adjoining owner consent. There is no standard form. What I can say is that the RGL is currently in the process of putting together a guideline for removal of limitations, and they've indicated that will be addressed in that guideline. Diane, can limitations be removed as part of a standard LT subdivision in the situation where all the abutting parcels are guaranteed and there is no question as to the definition of the existing boundaries? The answer is yes, the limitations can be removed as part of a standard LT subdivision, but it will still be subject to the either getting neighbours' consents or the RGL sending out notices to those adjoining owners. So I understand it, the RGL doesn't have discretion about that. That has to be covered off. So you're still going to have to deal with the, if you don't get consents, have to deal with the adjoining owner notice period of 40 working days, basically 2 months. In terms of the definition, I think you still need to be looking at those adjoining surveys and making sure they didn't leave residue parcels. If they're pre-2010 survey general rules for residue parcels were required, then those surveys would need to be investigated to see whether they intended to leave residue parcels.
Yeah, I'll just add to that too. If you remember what the requirements from the RGL were for removing limitations, that's part of that is to be satisfied that none of the land is held in adverse possession. So you've still got to carry out step 2 of the process. When you're doing that, even if the adjoining, the abutting parcels are in guaranteed titles, because it's possible that those owners have still occupy part of the limited title and have done since before the limited title was issued. So you've still got to carry out that process to enable the RGL to remove limitations. So you'd still have to produce an occupation diagram. You've still got to mark the existing boundary points. So you've still effectively got to do, the normal process for removal of limitations in terms of the survey work.
Okay. I think this is the last question from Kurt. I might have missed it, but what is the easiest method within Land Online to apply for approval to claim a non-live residue parcel? So yeah, if you're wanting to include a residue parcel that's effectively in a cancelled limited title, then you'll need to use a title information request in Land Online, and that is available to survey users and to title users. Okay, we're 10 past 1, so we'll finish up now. If there's any questions we've missed, we'll address them in the follow-up material we send out. If you have any further questions or comments about the guidance, as the slide on the screen shows, you can email them to customer support at linz.govt.nz and they'll find their way to us. If you have specific questions about a limited title survey you're undertaking, then please submit those queries in the usual way using our Land Online Survey Information Complex request. So thank you all very much for your attention.